This is Bloomberg Law with June Grasso from Bloomberg Radio.
I was scared for myself, but I looked around. I saw women and children. He was yelling in their faces, saying these threats. I couldn't just sit still.
Trial began this week for Daniel Penny, the Marine Corps veteran charged with recklessly causing the death of a homeless man by placing him in a deadly chokehold on a New York City subway train last year. The death of Jordan Neely ignited a firestorm of protest, debate, and division across the city and headlines across the country. Was Penny a good Samaritan or a vigilante? Penny says he was trying to protect himself and the other passengers because Neely was threatening them.
The three main threats that he repeated over and over was, I'm going to kill you, I'm prepared to go to jail for life, and I'm willing to die.
Jury selection in the case started on Monday. Joining me is criminal defense attorney Jeremy Saland, a former Manhattan prosecutor. How much of this debate about homelessness and mental illness and safety on the subway, how much will that bleed into the trial?
These are issues that hit home for many New Yorkers, but what happens outside the courtroom should remain outside the courtroom. What happens inside the courtroom should be regulated by the four corners of the law. I would not expect that any of it should come into the trial. The question is not what Jordan Neely did or didn't do days, weeks, months, and years before, criminal record, mental health illness, being homeless. In that moment in time, was Daniel Penny justified in taking action to subdue Jordan Neely and then ultimately cause his death, whether recklessly or negligently, as alleged by the prosecutors?
Neely reportedly had mental health and drug addiction issues. You don't think that his psychiatric history and the fact that synthetic cannabinoids known as K2 were found in his system, you don't think that will come in?
First of all, Judge Wiley, has been around the block in terms of the criminal law and criminal justice for years. He was actually my deputy chief when I was a prosecutor, and he's been on the bench a long time. I trust that he'll make the right call, and in this particular case, I think you have to set aside the noise, and again, not looking at his criminal history, his meaning Jordan Neely, not looking at his mental health issues. Was it relevant in that moment to the determination and the reasonable person analysis, if you will, of Daniel Penny when he observed this man throwing down his jacket, saying something along the lines of, I don't care if I go to jail, or whatever he might have said, and the reaction of people? So you have to limit it because you can't twist the jury and provide evidence that is not relevant into the determination and decision-making. Daniel Penny didn't know about the prior history. Daniel Penny didn't know about the mental illness. Did K2 cause Neely to act in a certain way? Maybe that could be relevant, but what did people see? What does the video show and demonstrate? And what happened in that moment is really an important factor, not days, weeks, and months before.
There's a 4-minute video of Penny pinning Neely to the ground and placing him in a chokehold while two other passengers helped to restrain Neely. And both sides say they're going to use that. How will they use it differently?
Well, I think that the defense is going to try to show that what Penny did was very reasonable in that moment. And he's holding and pinning this individual to the ground. And, there's other people who are helping him do so because they're equally concerned about the volatility and the immediate present danger, if not threat on lives of people on the subway. Whereas the prosecution is going to show a guy who was subdued and there's a hold around the neck and the chokehold, and probably concentrate more on that, which ultimately, if you believe their theory and they prove beyond a reasonable doubt, caused him to lose consciousness and ultimately pass, setting aside whether or not law enforcement did CPR and should have done CPR. So it's the same video, obviously, but one is going to try to demonstrate it was reasonable in the moment. The other one is going to try to demonstrate it was negligent or reckless and beyond the pale, if you will.
The medical examiner's office found that he died from compression to his neck as a result of the chokehold, and the manner was homicide. The defense said it's going to attack the ME's report and bring up potential other causes of Neely's death, including high levels of that K2 in his bloodstream. That usually works in movies. Does it work in the courtroom?
It can work in the courtroom, and this is sort of a response to what you asked me earlier. I don't necessarily believe the K2 is relevant to the reaction and behavior of Daniel Penny, but it can absolutely be relevant, and I assume we'll have a forensic and an expert, for lack of a better term, to try to establish this, that the K2 may have been that proximate and actual cause of death to Jordan Neely. So I think that's going to be something that they're going to argue, and it should be something. It sounds like it is. Does it work in real life as opposed to the movies? Every case is unique and every case is different. I believe that the big concern here is you have to make sure that you separate those jurors who have preconceived notion, whether it's race, whether it's politics, whether it's subway safety, take them out of the equation so that that jury objectively analyzes the evidence that's presented in that courtroom. So it does work. It absolutely can work. It's not an easy task or an easy lift, especially with such a charged case from the emotional perspective.
Both sides are going to call witnesses who were on the train, and it appears that their level of concern about Neely's behavior varied. Some said they were afraid. Others said, no, they see this all the time on the subway. Will their accounts sort of cancel each other out?
The testimony and the witnesses are not going to cancel each other out, for lack of a better way to describe it. The words that they use are going to be critically important because that video only shows a section in time. It doesn't show that imminent threat, because remember, by law, there needs to be that imminent threat of that serious physical injury or death even to allow for the justification defense or self-defense, if you will, of yourself or other people. So beyond that video, how do these people perceive those moments? How do they react? And I'd be very concerned as Daniel Penny's counsel and Daniel Penny personally, if witnesses are going to come up and say, you know what, you see this all the time. You put your head down. I'm a New Yorker. I've been around the block. I've ridden these subways late at night. You just ignore that moment and the threat, if you will, goes away. Because remember, too, it's not about just being scared or nervous or anxious. It's not a Kansas or Texan standard of riding a New York subway. It's arguably a reasonable New York standard or just a reasonable standard versus standard in what was observed in the moment. So you have to be careful. I don't think they're going to negate each other. The words and the specificity of why and how they believe that they're in physical or serious physical danger or imminent death, that's so important. So important. Not just that I'm scared.
What about the fact that he was a trained Marine? Does that come in?
It very well can come in if there is evidence that he knew and was aware of this type of chokehold and how to apply it and use it, and the potential consequences of it. Because remember, it's not an intentional crime, but did he know of these risks, Jordan Neely, and did he just really ignore those risks? Was there a substantial likelihood or risk that his actions were going to cause another person's death and he ignored it? Did he just disregard this person's well-being, meaning Jordan Neely? And if Daniel Penny was aware and knew and had that skill set, I believe that it should come in. It should be relevant.
Go over, what does the prosecution need to prove to get a manslaughter conviction?
So manslaughter is a little bit different than criminally negligent homicide, just like it's different from an intentional crime. When you're charged with manslaughter in the second degree, what the prosecution has to allege is that you recklessly caused the death to another person. Reckless is that standard. Whereas criminally negligent, which is different, and that's the lower felony, that's the Class E felony, that when you do so, you commit these acts, you fail to sort of perceive that there was this real substantial risk that your actions would cause that other person's death. So the recklessness is different, and it's more severe than the lesser, if you will, criminal negligence.
So the question looming over the trial, like every trial basically, is whether he's going to testify himself. And one of his lawyers said he'd be a great witness. We anticipate that he will, but that will depend on how the trial goes. Do you think he almost needs to testify to, show his state of mind at the time?
Defense attorneys, such as myself, we don't always show our cards like the prosecution does at this point in the trial process. A lot of this hinges on that witness testimony. Yes, that video was important, but I think that video can work against Daniel Penny too, because if someone is quote unquote squirming, as was used in the terminology by Daniel Penny, that's not a favorable term. And for all those minutes to hold that person there, what are these witnesses going to say? Are they going to articulate how and why they were fearful for their life, for their physical safety? Because if they don't, then Daniel Penny has to testify. If they do, and it's clear of this imminent threat and danger, then maybe Daniel Penny doesn't. But I would expect him to. I would suspect he will testify because he probably will come across as a sympathetic person, not trying to intentionally hurt another man, but doing what he thought was the right thing in that moment. True or not, that's for the jury to decide, but I would expect that he would testify.
You mentioned that Penny said that Neely was squirming. And the judge has ruled that the prosecution can introduce that video of him describing Neely as squirming to police and other things he said to police when he was being questioned.
The choice of words that Daniel Penny chose in the moment are probably words in retrospect he should not have. You're not necessarily thinking of the right words to use, especially if you're not technically in custody at the time and there's just an investigation. But to assert that Jordan Neely was squirming is not necessarily the right language when I think of someone being a violent threat to my life and safety or that of others. Squirming is more squirming to get away from someone, squirming to slip away and protect oneself. Not he was, flailing his arms, he was taking swings, he was cursing me out, he was threatening people, he was lunging, squirming. That's a difficult word. If I'm the prosecution, I might seize on that word of squirming because it's not indicative, in my view, suggestive, honestly, of those violent throws and violent actions. Whereas if I'm the defense, I may try to explain what I mean so I can explain it away and make it clear that in the moment when Daniel Penny was, obviously anxious and this had just happened, he may have chosen the wrong words, but the heart of what he was saying was the same thing. I was holding this person in a way that I felt was the best to achieve and the safest for everyone to achieve him from not hurting anyone or doing worse on that train. So squirming is something that I might seize on as a prosecution.
Police interviewed him on the day that Neely died and then released him. That was criticized by some elected officials, and protesters demanded that Penny be arrested. Will that come in?
So issues of something called a Huntley hearing, it's statements that are made, and whether you're in custody and it's an interrogation as a matter of law, those issues have already been litigated. So you're not going to hear that litigation in and of itself. But it could very well come in, and I would expect it to come in, that he was questioned and arrested only after the fact. Because the prosecution wants to tell a complete story. They don't want to seem like they're hiding the ball and misrepresenting. They want to explain why that occurred. Because if I'm the defense, I want to seize on that and say, you guys didn't arrest me initially. Look at, only because there was political pressure, only because of his outside voices and the issues of race and the issues of subway safety and politics did my client get arrested. And that's not just or justice. So I would expect it to come in with both sides trying to rationalize or reason why. And I will say that this is not incredibly atypical. Certainly most people are arrested in the moment, but there are times that not only does the NYPD not make an arrest initially, there are also times when prosecutors' offices, DA's offices, do what's called a DP, or a decline to prosecute a case, even after the process has started, for further investigation, only to later make an arrest. So this is not necessarily typical, but it's not atypical either.
So what kind of juror are you looking for if you're the prosecutor, and what kind if you're the defense?
Starting with the prosecution, I'm looking for a real New Yorker, which is the opposite of what the defense is looking for. I don't want my Florida, Texas, California, Iowa transplant. I'm not looking for the guy or gal who's been around the block once because they had to walk to school or their new job and they're so excited to be in the big city, bright-eyed and excited. Maybe mom and dad are paying the rent. That's the person that the defense wants, because the defense wants that overreacting individual who is not familiar with the subway life, who's not familiar with quote-unquote Gotham. Manhattanites are very, very different who've ridden that subway, who've lived their lives. So that is the type of juror that we would expect the prosecution to want. Say, you know what, put your head down, walk away, this too shall pass.
Would you rather be the prosecutor here or the defense attorney?
In this scenario, the one who's asking me was trying to be sneaky and sly what I think is going to happen. That's what I'm trying to do. I see through you. I see through you. It's not my first rodeo. That being said, if I had to take a side, which really sounds awkward saying that because this is such a tragic case no matter the result, yeah. But if I had to take a side from a legal perspective, I would want to take a side of the prosecution. I think this is an uphill climb from what I have seen. Granted, due process, 100% every single person, every single time. And the process has to run its course. We'll see the evidence. But that video is not some overwhelming piece of evidence that would say, oh my gosh, Daniel Penny, wasn't reckless or negligent. Remember, not intentional. It's not irrelevant. And those witnesses on the subway, from what I have read, which is not evidence, and we'll see that evidence. But what I've read, there's nothing so overwhelming. Oh my gosh, if you've ridden the subway in New York, this happened. This happened. It's terrible. It's sad in terms of people having episodes or manic episodes or misbehaving or even getting aggressive and violent. But that's something we see, and I would not want to be on the side of Daniel Penny. But let the jury decide that. It's not my job or role, nor is it the public. Let due process run its course.
The case is going to take quite a while, so we'll check back with you. Thanks so much, Jeremy. That's criminal defense attorney Jeremy Saland. Courts in battleground states are getting ready to fight potential security threats, and they're expanding resources to deal with an expected influx of election litigation. In states like Arizona, Pennsylvania, and Nevada, courts are announcing plans from speeding up election-related cases and shortening appellate deadlines to making sure every judge is on call on Election Day and creating new social media accounts to get out accurate information. Joining me is Suzanne Monyak, judiciary reporter for Bloomberg Law. Let's start by talking about the concerns that courts are having right now about the election. First, we've heard about these increased threats against judges and other judiciary workers. Tell us about that, if that's part of the concern now.
Absolutely. Threats against judges and other judiciary officials have been on the rise in recent years. We've seen the number of investigated threats by the U.S. Marshals more than double between 2019 and 2023. Obviously, now as we're heading into an election, these cases are they're high profile. They're watched, on a national scale. And so as we're seeing already this landscape where judges are at increased risk of threat, of harm, now they're handling a case of significant, potentially political importance, especially if it's in any of these battleground states. It may be a big decider in the election. So anytime we have judges handling cases like that, especially in this heightened threat landscape, there are just going to be heightened security concerns.
What are they doing about that? Are they giving judges more security?
Obviously, judges I spoke to for this story were hesitant to divulge too many, details about their specific security planning for obvious reasons. But we have seen quite a bit of, improvement. I'll say more resources given to security since the last election, for example. And a big reason for that is the tragic event that happened in summer of 2020 when the son of a New Jersey federal judge was murdered in his own home by a disgruntled attorney posing as a delivery man. And this horrible event was really a bit of a wake-up call for the judiciary on security. And so we saw Congress passed legislation a few years ago trying to crack down on, having publicly posted personal identifying information for judges on the internet, like their addresses. We're seeing judges being encouraged to use software to delete information that may already be online. The judiciary has changed their system to sort of try to encourage judges to have home security systems and then get those reimbursed. So we are seeing programs on more of a national level to, try to better protect judges. And obviously every year the judiciary asks Congress for more money for these security resources, and that's continued. So while there hasn't been, necessarily, more bodyguards for individual judges per se, we are seeing really an increased focus on this in Washington.
And so what are some of the other concerns that the courts are having now as, the election is approaching?
These security concerns, are true for election cases. They're, of course, also true for any, high-profile case you're dealing with, a celebrity or maybe some viral true crime case. But election cases can be kind of like a unique situation for the courts in that they can be maybe uniquely vulnerable to some of these disinformation campaigns we've seen targeting the judiciary. This might be, that judges are biased or, tilted for one side over the other. While at the same time, we're seeing a lot of, claims of election fraud, including from former President Donald Trump. So those two kinds of disinformation campaigns together can really just put, judges hearing election cases in a really uniquely difficult situation.
What are they able to do about the disinformation, either Russian disinformation or Trump's disinformation or all the rest of the inaccuracies we see online?
It's certainly a difficult problem to tackle. I think we've seen some courts try to chip away at it by trying to better publicize information about election cases, maybe having a landing page on the homepage of their website. So the public, maybe especially amid, increasing distrust in the media and reporters, the public can go onto the court website and click the case and see the filings for themselves. The Pennsylvania state court system, for example, a state where highly, expected to have some contentious election litigation in that battleground state, has, launched a Blue Sky page, a newer social media platform to kind of push out information about high-profile election cases. So I think we're trying to see more transparency from the courts, trying to make these cases accessible to the public, where like a court, docket page may not be quite as accessible to someone who isn't used to, wading through litigation. But at the same time, of course, these campaigns are a challenge on a national scale. And, there are researchers I've spoken to who really study disinformation, and they say it's coming from Russia and maybe other foreign actors, and sometimes from domestic actors as well. So, I mean, it's one of those things that, there's not one solution to, fight election disinformation. And I think it's become, of increasing concern in recent years.
Is there more emphasis on this in the swing states, the states that we think might determine the election? You mentioned Pennsylvania. That seems to be a must win.
Absolutely. I mean, of course, election litigation can happen anywhere. It can be contentious in any state. But I think I bring up the battleground states, these swing states, because I think probably the consensus is that that's where these litigation might have the greatest impact one way or the other. A state that is not a swing state is probably like the election litigation may just not have the same, national significance as one in a battleground state. And so that just means it's more likely to garner more public attention. And it's just when you're, having cases with this much public attention that you're more likely to see threats from the public. People who are scrutinizing these cases, they're scrutinizing the judges, they're calling chambers and threatening the judges if they don't rule in favor of, whatever, direction of the case they think will benefit their favored candidate. And so just, more national scrutiny, more national attention just is always going to bring security threats. And
you're right that some courts in swing states are trying to speed up election-related cases, and one has every judge on call on Election Day.
Yes, security is not the only challenge for courts managing this type of litigation. Sometimes it's just a resources challenge. It's an administrative challenge. These cases are filed in both state and federal courts, but perhaps largely in state courts. And depending on the court, they may just, the amount of resources these courts have really vary court by court across the country. Some of these courts just may not be used to handling a case that is so high profile and of such national significance. And with these cases also can come just like timeliness concerns. You mentioned, speeding up processing of cases. Election days in November, the inauguration is supposed to be, the following January. That really is a time crunch to be able to get through any very important election challenges that could determine the outcome of the whole election. And so we've seen courts, putting out guidance, shortening appellate deadlines to get these moving faster, asking judges to prioritize election cases, perhaps over other cases. And you mentioned on staffing, I had a former chief judge of a Nevada federal district court tell me that starting for the 2020 election, her court was having all active judges be on call for Election Day to make sure that if they had multiple emergency motions requesting emergency time-sensitive relief, they would have the resources to handle that.
And in these swing states, we're seeing a lot of pre-election litigation over some important issues having to do with not only who can vote, but how the votes are counted.
Absolutely. These cases, there's already been quite a few filed. So when I say that courts are, gearing up or so for election litigation, it's already begun. And I think we're expecting more to follow. Some of the types of cases that have been, filed so far, we've already had a state court in Georgia block a Republican election board's move to mandate that ballots be hand counted. Other litigation that's been filed has been, in Pennsylvania over whether ballots can be, accepted if they have the wrong date or they don't have a date. So just a lot of different types of issues in the election system regarding, mail-in voting, voter eligibility, that sort of thing, that we're seeing in battleground states across the country.
I saw you talk to Texas Supreme Court Chief Justice Nathan Hecht, and he said elections are hard on the judiciary because the public is thinking everything's political, everything, and that the courts must be too. And so judges are concerned about the public's perception of fairness?
I think absolutely. I think concern about public distrust in the judiciary has to be top of mind for judges. Their goal is, they want to be an independent, impartial decider, adjudicator. If the public, thinks that judges are biased, it certainly is a pretty significant hit to the judiciary's credibility. So, I think most judges, they see that. They see this trend in this polling while also seeing a rise in security threats to them. And I think it's concerning across the board. Judge Hecht he mentioned to me as well that, in some states like his, for example, judges run in partisan elections for their seats. And that's something we see in some state courts. And he told me that's not something he's actually for. And it's just sort of all of these things that can make it can erode really, I guess, faith in the judiciary and make it harder for judges to do their job.
I want to turn for a moment, Suzanne, to the controversy over that Alaska judge. Start by telling us about former Alaska Judge Joshua Kindred and the scandal surrounding him.
Yes, there's been quite the judicial ethics saga coming out of Alaska. Former Judge Joshua Kindred, who was a Trump appointee, resigned in July amid findings by the Appellate Court Judicial Council that he had engaged in very serious sexual misconduct, including sexual harassment with his former clerk, as well as inappropriate relationships with attorneys who appeared before him, and he lied about it to judicial investigators. This judge has since resigned, but in the wake of his departure, we have seen now significant potential conflicts of interest in some of his past cases, involving those where he might have had an inappropriate relationship with one of the attorneys in the case.
Defense lawyers obviously have looked at the conflicts of interest and tried to take advantage of them. And actually, one judge has ordered a new trial in one case.
Yes, both the Alaska U.S. Attorney's Office and federal defenders have identified dozens of cases where there may have been potential conflicts of interest. These include cases where Judge Kindred, saw the case through to the end, as well as cases where he recused midway through once the judiciary started investigating him and his ties to some of these lawyers were revealed. And so that would be the defenders at least are taking a look to see if there's an avenue for relief for their client. And yes, as you mentioned last month, we saw that for the first time. We saw an Alaska federal court case being overseen by a visiting judge from within the circuit actually ordered a new trial for a defendant because in his case, though this attorney had not actually been officially an attorney of record for the prosecution, she had a supervisory role. This is an attorney who had been found by the Judicial Council to have sent explicit photos of herself to the judge as a part of some sort of flirtatious relationship the two of them had. And as a result of that fact that she had sent those photos and had a supervisory role in the case, the judge felt that there was, at the very least, an appearance of a significant conflict that merited a new trial. This guy's going to get a full redo under a new judge.
And so for the first time, federal prosecutors are asking to have a case thrown out, a criminal conviction in one of Kindred's cases.
That's right. Up until now, we've seen, requests by defense lawyers largely, mostly on the criminal side, though at least one civil case, trying to have, decisions against their clients thrown out based on the presence of this attorney who sent photos to the judge. And then last night, we saw it really go a step further when the Justice Department itself, as part of its own case review, identified a case where it felt that it was such a significant conflict of interest that had to bring it to the court and asked to vacate a conviction that had happened 2 years ago as a result of the judicial and, really prosecutorial misconduct here. They, for the first time, publicly identified the lawyer who had been sending the nude photos to the judge. Bloomberg has already reported her identity, but had been unnamed so far in public court filings. And they revealed that this lawyer had had ex parte conversations with the judge about this case. So just, really serious disclosure regarding prosecutorial and judicial misconduct here.
The Justice Department told the court it learned from a hearsay source about an ex parte conversation the judge had with this prosecutor?
Yeah, absolutely. That's a very significant disclosure, especially to hear it straight from the Justice Department. I think there's been speculation among the defense bar that, if the judge is, having this flirtatious, sexting relationship with a prosecutor, that perhaps there's conversations happening between them about cases, but to hear it from the Justice Department itself was significant. And this also isn't, the first time. We already saw a request this time earlier by the defense bar regarding the judge having, conversations with another prosecutor in the office who wasn't actually on that case. This has, been raised before that this judge had been having, sexual relationships of some kind with more than one prosecutor, and what kind of conflicts are those going to present for the defendants in his courtroom.
I was just interested in this. You said that the motion to vacate was signed by Stephen Clymer, a veteran fixer recently deployed to Alaska. What do you know about that?
Mr. Clymer was, deployed over to the office, just a few months ago. My colleague, who's a Justice Department reporter, was the one to report on his entrance, and he's since filed his name in multiple dockets of cases that are being reviewed. And I think it really just goes to show that the Justice Department sees a problem here, that they've now brought in somebody with decades of experience in these kinds of issues to be, going to Alaska, filing, an appearance on these dockets and engaging in this case review to find potential conflicts between the judge and attorneys with the Alaska U.S. Attorney's Office.
And it's probably going to be years that this saga is going to play out. What an unusual case. Thanks so much, Suzanne. That's Bloomberg Law judiciary reporter Suzanne Monyak. And that's it for this edition of the Bloomberg Law podcast. Remember, you can always get the latest legal news by subscribing and listening to the show on Apple Podcasts, Spotify, and at Bloomberg.com/podcast/law. I'm June Grasso, and this is Bloomberg.